5 seconds to go. Start. He preferred an application being the criminal miscellaneous application number 32494 of 2009 under section 482 CRPC before the High Court of Allahabad, seeking to quash the proceedings of case number 67A of 2009 State versus Ram Prakash Gunkar and others arising out of the said charge sheet in case crime number 617 of 2007 pending before the CJM Firozabad. During the pendency of the aforesaid two applications filed under section 482 CRPC before the High Court, the Court of Additional District and Sessions Judge Firozabad completed the sessions trial number 753 and 753A of 2008 respectively and void the judgment and order dated 10th July 2015 held all the 12 accused including Ashok Dikshit guilty of the offences under sections 147, 148, 149, 307, 302 and 120B IPC with which they were charged. The relevant observations made by the trial court are reproduced herein below. The plea of alibi taken by accused Ashok Dikshit that on the day of incident he was lodged in jail under section 34 Excise Act at PS Murad district Gwalior was with the inconsistent report of the Murad police officials, and after investigation IO had submitted its report to SSP Gwalior and JM Gwalior and stated that the case was false. The above mentioned police officials have been suspended after conducting a departmental investigation. Also, they have been named for conspiring the death along with accused Ashok Dikshit in the charge sheet that has been presented before CJM Firozabad, in which they have been charged under section 302 120B IPC. It is correct that the distance of 160 kilometers cannot be covered in 1 hour, and if accused Ashok Dikshit was at Murad Gwalior at 9:30 am, then he cannot be involved in the commission of incident at Firozabad at 8:30 am. It was contended in this regard on behalf of the prosecution that accused Ashok Dikshit is a cunning criminal. He showed his presence there colluding with Murad police station Gwalior in order to escape himself from the offence of murder. The investigator SHO Shri Baldhari Singh made enquiries after going there. Then the whole matter was found forced and the investigator gave an application to SSP Gwalior in this regard and also submitted an application before JM Gwalior Madhya Pradesh, and keeping the investigation in progress, it was found that in order to save accused Ashok Dikshit from the heinous crime like murder, the forced arrest and his release on bail has been shown by the police of Murad police station. SSP Gwalior on investigation finding the whole case forced has suspended all the officials involved in the said matter and initiated departmental inquiry against them, and after collecting the evidence in the said case a charge sheet has been filed in the court of CGM Firozabad against the said police officials Niranjan Upadhyay, TI Police Station Murad Gwalior, and Silendra Singh and Triloki Gaur, and ASI PP Gunkar, Head Constable Vijay Bahadur, and Head Constable Ram Baran Yadav under section 147, 148, 149, 307, 302, 201, 120B IPC with regard to give cooperation in the conspiracy of murder under section 120B IPC. A case number 67A of 2008 State versus Niranjan and others is pending in that regard in the court of CJM Firozabad, and the warrant of the arrest of the accused persons have been issued. The said file pending in the court of CJM was summoned on behalf of the prosecution in this regard, which is available on the file of the instant session trial, which makes it clear that accused Ashok Dikshit has shown his presence at 9:30 am on the day of incident, showing his arrest under section 34 of Excise Act in order to escape from the case of murder of Suman Prakash, colluding with the police officials of Police Station Murad, District Gwalior, Madhya Pradesh, which was found forced in the investigation, and charge sheet has been filed against the said police officials involving them in the conspiracy of murder, and in order to save accused Ashok Dikshit from punishment. The case of the same is pending in the court of CJM Firozabad, and warrant of arrest against all the police officials have been issued, and SSP Gwalior had suspended them, and departmental inquiry has been initiated against them. All these police officials are absconding. Arrest warrants have been issued against them by CJM Court Firozabad. The copy of charge sheet of case number 67A of 2008, State versus Niranjan and others, pending in the court of CJM, has also been filed on record behalf of the prosecution. The proceedings of case number 15003 of 2007, State versus Ashok Dikshit under section 34 of Excise Act, Police Station Murad, pending before the CJM court, has been stayed by order dated 25th August 2009 by the Honorable High Court Bench at Gwalior, passed in miscellaneous case number 5971. The copy of the order passed by the Honorable High Court Bench at Gwalior is filed on record from 613B 25 to 613B 30. SLP has been filed against the said order before the Honorable Supreme Court, which was not admitted for hearing. The copy of the same is filed on record at 613B 31. Therefore, no profit of case under section 34 of Excise Act cannot be given to accused Ashok Dikshit and his presence at Murad, District Gwalior at the time of incident under the case of 34 Excise Act has been found forced, and the accused has made a forced plea of alibi colluding with the police officials. The High Court at Allahabad heard the criminal miscellaneous writ application numbers 4080 of 2009 and 32494 of 2009 analogously, and disposed them, vide the common judgment and order dated 19th April 2018. The High Court quashed the proceedings in case numbers 67 of 2008 and 67A of 2009 respectively, essentially on the ground that sanction to prosecute the respondent numbers 1, 3, 4 and 5 respectively under section 119 CRPC was necessary, and since it had not been obtained, the trial cannot proceed. The relevant observations are reproduced herein below. Admittedly, the applicants are public servant, and case was registered under section 34 Excise Act against main accused of the murder in the discharge of public duty, but the sanction to prosecute for the offence committed at Firozabad was not granted by the state of MP to prosecute the applicants for the offence committed within the jurisdiction of the police station Dakshin at Firozabad, UP, as is evident from the annexure SA1 and SA2 to the supplementary affidavit. In the above circumstances, it ought not to be proper to allow the proceedings to be continued against the applicants, and in case the proceeding is allowed to continue against the applicants, it would be nothing but misuse of process of law. Stop.